I'm reading Disability Rights Law Casebook by Sam Begenstos on page 608. I left off in the notes regarding notice and serial litigation, and I already read part A. So starting with part B, the burdensome litigation argument. A second argument against serial ADA litigation focuses on the large numbers of accessibility suits plaintiffs have brought and on the burden those suits place on the courts. Not surprisingly, businesses that are sued by serial litigants complain that firms filing lawsuits to force compliance have tied up federal court dockets. But it is not just defendants. Federal judges have made the same charge. In a newspaper article published in September 2004, Judge Dikaran Tevrizian of the United States District Court for the Central District of California was described as troubled by the flood of litigation. There are roughly 40 ADA lawsuits on his docket, he said. Multiply that by all the federal judges in the country. It's causing a lot of court congestion. And in decisions dismissing on other grounds ADA accessibility suits brought by serial plaintiffs, courts have gone out of their way to decry the burden imposed by the large numbers of lawsuits filed by such litigants. Complaints about a blizzard of lawsuits filed in an alarming volume that clutter up our courts and make it tough on everyone, also received attention at the hearings on the proposed ADA Notification Act. Strikingly, the opponents of serial ADA litigation have essentially acknowledged that the bulk of the lawsuits about which they complain have targeted businesses' conduct that in fact violated the law. In the hearings on the proposed ADA Notification Act, Representative Mark Foley, the bill's primary sponsor, explained that state bar discipline could not be relied upon to regulate serial ADA litigation because it is hard to prove the lawsuits are frivolous if violations do exist. Joseph Fields, an attorney who represents businesses that have been sued by serial ADA litigants, similarly explained that his clients need legislative protection because they have no adequate defense. When his clients are sued, Fields has to tell them, no, you are not in compliance. As one federal judge recently noted, engaging in only a bit of hyperbole, it would be difficult to find any restaurant, specialty store, service station, or other public accommodation between Chico and Sacramento which does not have some barrier to disabled access under the Americans with Disability Act accessibility guidelines. Part C, the outside agitator argument. A third frequent argument against serial ADA litigation asserts that the plaintiffs in such cases are not connected to the communities in which they bring suits, and that they challenge barriers about which local residents with disabilities have never complained. In media coverage of serial ADA litigation, this argument has taken on some of the overtones of Southern criticism of outside agitators during the African American Civil Rights Movement. Thus, one editorial that's criticized serial litigator Jarek Molsky for traveling throughout Southern California finding violations of requirements in the Americans with Disabilities Act, asserted that in many of Molsky's cases, other disabled folks found no fault and used the facilities with ease. And Walter Olson, in his attack on what he called the ADA shakedown racket, prominently featured the claim of recently sued businesses that no person with a disability ever complained about their facilities. So too, in the ADA Notification Act hearings, where Clint Eastwood set the tone by calling serial ADA plaintiffs' lawyers self-appointed vigilantes, one witness criticizing a series of suits against inaccessible businesses in Palm Beach, Florida, emphasized that the lawsuits were not filed by a Palm Beach County resident who would likely be seeking the services of the businesses, but by a Broward County resident. Another witness criticized an attorney for door-to-door developing a cottage industry based upon a single client who went door-to-door in Hawaii suing public accommodations and subsequently moved to the San Francisco area where he is doing the same thing. Page 610. The outside agitator argument has not been confined to the media or the political arena. Courts have frequently invoked the argument in the course of dismissing ADA public accommodation suits for a lack of standing. In a large number of cases brought by serial ADA litigants, courts have relied on the distance between the plaintiff's home and the defendant's business as grounds for concluding that there is no real and immediate threat that the plaintiff will visit the defendant's business again. Where some courts, particularly in the Middle District of Florida, have considered it a factor weighing against the plaintiff's standing that, though the defendant's business is not accessible, other similar businesses in the area are accessible. These rulings directly contradict isolation and segregation of individuals with disabilities as the principal target of the ADA.